Julia. She is a Ugandan jurist currently serving as a judge on the International Court of Justice, ICJ. She is also the Chancellor of the International Health Sciences University in Kampala, a position she has held since 2008. She's going to talk about the International Court of Justice, holding sovereign states to account for human rights violations. You have the floor, Madam.
Thank you, Madam Chair, and I take the opportunity also to thank our hosts, Mr. Ogmundu and his team, and also the ICD for hosting us to this wonderful roundtable conference. Last week, we had an anniversary, a 70th anniversary of the International Court of Justice, and it was a time for us to really take stock of how the court has done. And for me, I think it's fitting in this conference to talk about the role of the court and the challenges it has met in implementing human rights instruments. As you know, the role of the court, or the primary role, is to settle disputes between states, not individuals. And in doing so, the court does not make its own law. Instead, it applies what states have already agreed upon in terms of treaties, conventions, and even customary practice. So that is what the court does. One of its handicaps, of course, is that human rights are rights accredited to humans or individuals or groups of individuals, and yet these subjects do not have direct access to the court, especially where a state is the one violating the human rights of an individual or of a group of individuals. So access to court is problematic in that regard. But secondly, even where a state would be held accountable, it is not automatic unless that state has agreed to subject itself to the jurisdiction of the court. So those are two primary handicaps or limitations within which framework the court has to operate. Nonetheless, as a principal judicial organ of the UN, the court has tried in the last 70 years to play an important role in fulfilling the fundamental principles and objectives of the organization, which of course include the protection and promotion of human rights. This, I'm going to look at only three aspects, and there are several aspects in which the court does that, but I'm going to look only at three. The first is the way or the pronouncements that the court has made in relation to these important instruments, as the first speaker has alluded to, that states very often make or sign and ratify these instruments. And these instruments, to a large extent, remain on paper unless and until they're tested in the International Court of Justice, and they're brought up for either application or for interpretation, and then the court has a role to play there. So the first aspect I'll speak about is the court's pronouncements on the status of human rights norms. Second, I will speak upon the position, the court's position on the scope of the application of human rights instruments, and lastly, on the court's role in actually enforcing the human rights. So, as far as human rights are concerned, there is the famous Barcelona Traction case of 1970, where the court identified a category of international obligations concerning the protection of basic human rights, which obligations it said were owed to the international community as a whole, and which are by their very nature the concern of all states. These were, to use a Latin phrase, obligations erga omnes. And in view of the importance of the human rights involved, these obligations could be invoked by any state. And in that case, the court singled out a number of obligations for states. For example, every state has the obligation to prevent acts of aggression. Every state has the obligation to prevent and punish genocide, to prevent slavery, to prevent racial discrimination, and every state must promote the right to self-determination in as far as they're able to. And of course, also certain fundamental principles of international humanitarian law, which, for example, prohibit the murder of civilians in occupied territory, the deportation of civilian inhabitants to slave labor, and the deportation of prisoners of war to slave labor. All these were recognized by the court. These are not things that you would find in a listed out nicely in a treaty, but by the court interpreting certain treaties in a given setting, within a certain set of facts, the court came out with this kind of jurisprudence. Again, in relation to its first role, which I've said is the pronouncements that the court has made, in relation to the Universal Declaration of Human Rights and the UN Charter. The court has pronounced itself on the binding nature of the human rights clauses in the UN Charter, as well as the UN Declaration on Human Rights. In the advisory opinion on Namibia, or Southwest Africa, the court at that time held that the right to self-determination was a fundamental right, and that the denial of such fundamental human rights was or is a flagrant violation of the purposes and principles of the UN Charter. And this was, of course, South Africa at the time was a member of the UN. It had trusteeship over a province that it had taken under its wings, Southwest Africa, and within that province, they were still practicing apartheid. And they were denying the people of Southwest Africa the right to determine themselves. And this is where the court came in to say that. Again, talking about the UN Declaration of Human Rights, in the Tehran hostages case, this was a case where Iran had taken US hostages, diplomats hostage. The court said that it's wrongful to wrongfully deprive human beings of their freedom and to subject them to physical constraint in conditions of hardship is in itself manifestly incompatible with the principles of the UN Charter and of the Universal Declaration of Human Rights. So for Iran at that time, this was like a big blow for the court to say, Iran, you are wrong. There may not be a specific treaty, but within the UN Charter itself, what you are doing is incompatible with the principles there. So you cannot be signatory to the UN Charter and continue to do what you're doing. Now, on the scope of the application of human rights treaties, the court has also confirmed that human rights instruments continue to apply in times of armed conflict and in the context of occupation. For example, in 2004, when the court was approached by the Security Council, or I think it was the General Assembly, for an advisory opinion on Israel's construction of a wall in occupied Palestinian territories, and everything around what that construction, the effect of the construction of that wall, the court confirmed that whilst the jurisdiction of a state is primarily territorial, that means Israel had jurisdiction to do whatever they wanted inside Israel, but Israel as a party to the International Covenant on Civil and Political Rights, the International Covenant on Economic and Social and Cultural Rights, and to the Convention on the Rights of the Child, was bound to apply those same conventions within occupied Palestinian territory where Israel exercised its jurisdiction. I think this was a big lesson to all states who venture outside of their territories and hope to do as they please to the people of those territories, simply because they're occupied, they think that they will not be bound by the conventions that they've signed. And the message from the court was, yes, you are bound, and you are bound to apply those conventions to the Palestinian people even though you consider them unoccupied people. A year later, in 2005, in the case between Uganda and the DRC, or rather the DRC Congo against Uganda in the armed activities case, the court also noted that international human rights instruments were applicable in respect of acts done by a state in the exercise of its jurisdiction outside its own territory. What that meant was that what the Ugandan armed forces had done in violation of human rights carried out on the territory of another state, the DRC Congo, was binding on Uganda. They were bound, just as they were, towards their own people to respect the human rights of the Congolese, especially considering that they were on foreign territory. And of course, what happened was the court at that time condemned the country of Uganda to compensating and paying reparations to the people of Congo based on that kind of judgment, where Uganda, I think, had hoped that because they were acting, or these acts took place on foreign soil, no one would bring them to book. And that's not what the court said. Now, the third aspect, and I finish with this, is how the court has enforced human rights. Now, despite many jurisdictional obstacles, the court has had opportunity. One, to enforce human rights directly through a finding of responsibility for violations. Usually, that is a declaratory relief. Before I joined the court, I didn't quite understand how that could be a relief. But I can assure you, when the president of the court reads a judgment and says, country X, we declare, or we adjudge and declare that country X is in violation of such and such a treaty. It's like, if you like, naming and shaming that country for breaching a treaty to which they should be beholden and to which they should be upholding. So a finding of responsibility for violations, usually accompanied by an order for reparations, is quite powerful. And of course, that's the second way that the court acts, is through determination of appropriate remedies. And thirdly, through the indication of provisional measures aimed at protecting human rights pending a case being heard. Now, as examples of a finding of a violation, again, I'll give the well-known example of the advisory opinion of the court in the Israeli case. Now, remember, that was just an advisory opinion, and you might argue it was not binding. Israel didn't even bother to pitch. They made no statement at all. They weren't interested. And many states do that. A state will file a case, like recently, we had a small state known as the Marshall Islands take on the 9 nuclear weapon states, individually, one by one. Now, 3 of the states already had recognized the compulsory jurisdiction of the court and made their defenses, but 6 didn't even bother to pitch in even a letter acknowledging that a case had been filed against them, even though the court wanted. So this is the way that the court or the system works, that sometimes, states, it's within their prerogative to respond or not to respond. In the Wall advisory opinion, in addition to the court giving a declaratory judgment or finding, it wasn't a judgment, but a declaratory finding that Israel was responsible for violations in the occupied territories, the court went as far as saying that the Israel had to pay reparations to the victims, and went quite far in that regard. There's another set of cases that's interesting, where the court had given what they call provisional, or had indicated provisional measures against the United States for, I think there was a set of German nationals in the Legrand case and a set of Mexican nationals in the Avena case who were incarcerated in domestic courts in the USA and had been convicted of crimes, capital crimes, and their lives were in dire danger of execution. So these two states, Germany and Mexico, filed cases in the International Court of Justice to challenge the actions of the USA, claiming diplomatic protection for their subjects, and asking the court, in the meantime, and until the case is heard, that these lives be saved by the US courts not carrying out the execution, at least until the court has listened. Of course, the mighty US, being what it is, did not did not comply with the provisional measures, and all these people were executed. The statute of the court says that where a state does not comply with the judgment of the court, the complaining state can access the United Nations Security Council, and you can imagine what happened there when these states tried to take the United States to the Security Council. I think I want to close with the conclusion that despite the many procedural and jurisdictional hurdles, the ICJ remains firmly committed to upholding and enforcement of international law, of which human rights forms an integral part. As the world faces new challenges, such as terrorism and religious extremism, and as individual human rights are more and more under threat of erosion by state action, it is my hope that the court will rise to the occasion in meeting the challenges ahead and in playing a leading role in developing relevant jurisprudence that will strengthen the observance and respect for international law. I thank you.